You might think that it's not realistic to be doing something illegal for 20 years or more and it going unnoticed. But that's exactly what happened to one couple when they were asked to leave their home after living there for more than 20 years. And they were not the only ones. So welcome back, but if you're new to me, I'm a barrister who helps you understand law. And in this video, a fairly heart-wrenching story where a couple was asked to leave their home of more than 20 years. You see, the problem with it was this. It was supposed to be a holiday home. They were not supposed to be living there permanently. The rules require that, and the law requires that you have a permanent residence instead of living full-time in a holiday bungalow. But it's even more complicated than that. You see, the couple didn't think they were doing anything wrong, and on one analysis, one might be persuaded to agree that there's absolutely nothing wrong with what they were doing, because they were even paying council tax to the local authority. The couple would pay their rental slips and they would pay over £100 in council tax every single month, and the council should have been aware that they were permanently living on the property, because holiday lets do not ordinarily attract any council tax. So for them to have been paying council tax, you could well argue that the council knew that they were living there permanently, and since they were living there for 20 years, it's entirely possible that legal challenges could be made, because after all, living there for that amount of time and the council knowing about it, it could give rise to the argument that it would be unfair for the council to ask them to move. But during COVID, and obviously everybody was confined to their own home, the rules required that everybody on the caravan park would leave. In fact, I've been instructed on many cases such as these, where residents had been paying fees to the caravan park but not being able to use it because of the lockdown. This gave rise to arguments over breach of contract and force majeure clauses and so on and so forth. In fact, lots of my civil and commercial and consumer practice has been based around breaches of contracts over the COVID period. However, given that the couple were already living on the caravan park permanently for many years, they were already in breach of contract. However, no such claim as reported was brought against them for it. So this brings us back, as ever, to the warning that you really should read the terms and conditions. Now, most people don't read terms and conditions. In fact, just this morning I've updated some software. There was a checkbox to say that I've read and I accept the terms and conditions, but I don't have time to read those terms and conditions. It's a piece of software. It should do what it's designed to do. It shouldn't do anything that it shouldn't be doing. And broadly speaking, I just don't have time to waste on something that might be inconsequential for the most part. And if there's anything really detrimental, then it's going to be an unfair and an unenforceable term anyway. But when it comes to a holiday let and something that you're paying a lot of money for, particularly if you're going to live there, and there's going to be a lot of implications to you whilst you're on holiday, or for the amount of money that you've paid for this thing in the first place. In this article, it was well over £20,000, and not just a bit of software that's about £30 a year or so. When one is paying this amount of money, I would strongly recommend that you come to somebody just to have a once over the terms and conditions. It might only take 1 hour of a lawyer's time to breeze through the terms and conditions to find anything that stands out as being particularly unfair, particularly unjust, or just a red flag that you need to watch out for. As a barrister, I've done this lots of times because some of you guys have come to me and said, here's a contract, this is what they're saying, what do you think? It might only take 1 hour for me to go through those terms and conditions for you to ensure that you're not going to be caught in an unfair situation, but one that isn't so unfair that it makes it unenforceable. In fact, just recently, there's been a flurry of messages by coincidence about vehicles that have been sold as seen, not roadworthy, brakes that aren't working properly. Now, as a reminder from previous videos, it is a criminal offence to sell or even advertise for sale a vehicle that is not in a roadworthy condition, irrespective of whether it had an MOT certificate, because if there's been damage to it in between times and there is something wrong with it, then it's still a criminal offence to be selling that vehicle if it's not in roadworthy condition. And all of the general disclaimers such as sold as seen, no warranty, no returns, and all of these things are usually not worth anything because it's still a contract of sale. If it's with a business, that is, it's got to be fit for purpose, it's got to be as described, it's got to be of satisfactory quality. When looking at those things, if it is a second-hand vehicle, obviously it might have some dents and scratches and it's not going to be in brand new condition. But conversely, if it's a brand new vehicle, the Consumer Rights Act provides that it should be free of even minor defects. So coming back on point, this couple must have not just been disappointed, but must have been devastated to have had to leave what they've called their home for over 20 years all because they didn't understand the terms and conditions, or because they maybe justifiably thought that they were doing nothing wrong, because it was even backed up by the fact the council was accepting council tax. And another argument might be, not that this is legal advice, but if they're watching, or if anyone in that position is watching, or if you know anyone in that position that might be watching, if they've been paying council tax at £120 a month for 20 years, there might be an argument to go back to the council and say this was paid incorrectly, it's paid in error, so please repay it. At the very least, with the statute of limitations, it would encompass at least 6 years, so they could potentially go back 6 years, go back to the council and say, we want that money back because it was paid in error. So £120 a month times 12 times 6 is quite a lot of money. So anyone in that position, not that this is legal advice, might think about doing something like that, because if it was paid in error to the local authority, it shouldn't have been paid and it ought to be repaid, refunded. So I hope this video is useful. Please do consider the terms and conditions when you're entering in some kind of contract. Let me know in the comment section below what you think of this story. Should they be allowed to stay there, for one? Should they be allowed to have the council tax refunded as a second? And should they be compensated in any way for being led to believe that they were allowed to live there permanently? I'll be interested in your thoughts and your feedback, and I would be really grateful if you could hit the like button and subscribe, because that's the way we tell YouTube that you find these videos useful. And as always, thank you for watching.